this time, I'd like to call the July 17th, 2012 Planning Board meeting to order. The first item on the agenda are minutes from July 10th. Mr. Secretary.
We're not ready. I've got some comments on the minutes from July 10th, but I haven't made the changes yet, so I'd like to hold off on voting them.
Okay, so you want to vote, so we table the minutes?
Table the minutes till next week.
I need a second. Okay. Discussion? No. All those in favor?
Aye.
Aye. Opposed? Abstained. Okay, so those are tabled. And you were waiting for comments from us?
Well, I got comments tonight, I just haven't put them in yet.
Got
I
it.
need a little bit more
Okay.
time.
The next item on the agenda is an approval not required. Are there any of those from the staff? No.
No plans tonight.
Okay. The next item on the agenda is a discussion. There are two things we will be discussing tonight: the wind energy system draft zoning bylaw, and then the general residence section 24026C of the zoning bylaw. So we'll start with the wind energy system draft zoning bylaw. Everyone received you had access to a electronic version of the draft that we're working on. There are a considerable number of changes and additions that are in red. Brian, maybe if you could just run through
Sure.
if there are any.
We should give a color version because there are various types of changes. What you see in red is going to be added. And what you see that is crossed out and underlined are changes to the previous versions of this bylaw that you had over the last few weeks.
Right.
Sorry to get it out to you Monday. It's just that you can see from the red that's on here, there's a considerable amount of new information and new technical, I call it turn the crank type stuff, because the board has, I think, done a lot of the hard work already defining what it is you want. And most of it is self-explanatory. If there are any immediate questions from the board members with regards to what we've added, I'd be happy to answer them now, or if you want, I can simply go through the step-by-step with you.
Brian, maybe I can lead us through this. Are there, under definitions, I guess, which is where there seems to be a fair number of changes, additions and so forth.
Right.
Can you just point out which ones are new from last week? Because
we added net metering, we added the power grid, we added the pure tone sound, we added broadband sound, we added flicker.
wait a minute,
Everything you
just
see
slow
there
it
in red?
just a little bit. Broadband,
Everything in
sound,
red.
got it, yeah. And you added flicker, right, okay.
Because a lot of that information you're going to find back under the sound modeling requirements.
Right.
So we added these in because we added those performance standards and those application requirements further on in the bylaw. We also, as you can see, are still kind of struggling with making sure everything is wrapped up fairly tight with regards to some of the other definitions, like accessory use, it's an accessory land use. We want to be precise in these matters. Ambient means ambient sound levels. So you can see now that we're starting to really sit down here, take our time, and truly refine this. There's no such thing as a bulletproof bylaw, but we try to be as precise as we possibly can. So it's reading, you're getting into your third draft, or fourth draft. So we're going to start tightening this up. Pretty fun. The other issue I have for you to discuss tonight is your public outreach area under your definitions.
Could we stop just 1 second? I'd like to ask the board if there are any comments or questions about the definition section. Yeah, Paul?
Definition, net metering refers to a billing period. Is that a monthly or annual billing period?
I'll have to find out for you. This is a standard definition. I think we took it from the state bylaw, but I can find out.
I think that's important because certain times of the year it might change significantly.
Okay. Other comments or questions about definitions? Yes, Doug?
I guess that's the first time I've heard that term, pure tone sound.
Okay.
And can you tell us a little about that? Do you know, or is that just something you passed along?
I'm no sound expert, but it's something we want to be able to test for. There's sound that becomes noise, such as we see the 10
Jason said
decibel.
frequency, sound, pressure, does it? That's a mouthful.
This is more of a, I'm going to give you the exact definition for it, or what it will sound like, but it's something that I want to be able to test for the sound that you can hear. Like a hum.
DPA.
Other comments or questions on the definition section? Okay.
One of the things.
Pat, excuse me.
Now, pure tone sound, what is the significance of that? Like Doug, this is the first time it's been brought up in regard to wind turbines.
It's something the state tests for. It's the state model bylaw. When we find out exactly why it was inserted, there was a discussion about whether we wanted that in there or not. But my understanding is it's something we should have in there.
Okay.
So when you find out a little more information.
Yeah, because somehow, somewhere, I understood that pure tone is something that we don't want. But I don't know whether it's at a particular rated level or what. That's why I'd like
Yeah.
to know a lot more than
And it's-
just.
And it's further on in the bylaw. Once you see, once you get to the sound setback, you'll see some information there that allow you for a better understanding. But we put it in there for now. We find out some more information why it's included in state models and other jurisdictions test for it. We find out precisely before you do it.
Okay, thank you.
Because we'll be discussing this next week, in the first week of August, so still have some time before the hearing.
Mr. Chairman?
And a why.
Yeah. Oh, right.
On the ambient sound level, the number 90%, is that a standard number that's used?
Yes.
Because an average 90% of the time is pretty much all the time.
Right, that's our ambient. In other words,
And if
it's-
you're sitting near a highway, the 90% may be very different, depending on the
This is your,
traffic volume.
and this is your quietest moment usually. So that's the standard number, 90%. I don't know of any other measure that's utilized, 80%. But this is what the guidance we have is, and I've seen this time and time in other jurisdictions. Suggestion is to stay with 90%. I'll find out. A little question mark. Get you better answer. In other words, these are definitions that I didn't come up with. These are things we're taking from other jurisdictions and other laws. We didn't come up with these numbers.
Okay. Other comments or questions on the definitions?
The other one's
section?
pretty technical. The pure sound tone, again, is adjacent center frequency sound pressure levels is a mouthful. And I'm not sure what that means.
We'll have to research that.
Okay,
Yeah.
well, let me find someone who can speak with a voice of authority on this topic. So you can have, and I'll find some background information for you, so you can read up on it. And we'll email that to you before the next meeting, so you can read up on what that is, what it says, and why we would have it in the bylaw.
Doug?
Maybe at some time during our process, we should have some sort of person who's qualified to tell us about sound measuring and stuff to speak.
Okay. That's fine.
Anyone else? Any other further questions on the definitions section?
I do have a policy question for you. At the last time we discussed this public outreach area, we were talking about having this variation in that public outreach area based on the system height of the wind energy system. And after talking with others in the assessor's department, we ran into some practical difficulties in doing that. And then there was some uniformity questions. So under the public outreach area definition, you can see we changed that. We changed it from those properties located within a radius equal to 4 times the system height to that area between 300 feet of the foundation, oh, I'm sorry, property boundary. Change that. Property line. When you see the words previous foundation, that's going to change the property line. We've had that area from 300 feet, which is this, where you stop for a special permit under the state law. And we've used the number 1,500. So it's that area that we would also send just a regular letter to somebody stating that, you know, your public comments were welcome. That you wouldn't have that party and interest status as part of your special permit. The 1,500 feet is a number I threw in there. My question to the board is whether or not you're comfortable with that. I think somewhere along the line, last week we had discussed, or I had mentioned 1,000 feet. The board didn't seem comfortable with that. That's over a quarter mile at 1,500 feet. Go with that for now?
Okay. So the public outreach will read as how?
It'll be those properties located between 300 to 1,500 feet from the property line. Because the proposed when you alert the abutters, it's from the property line, so that needs to change, that's all.
Okay.
And this is for what size?
The public outreach?
All sizes. All sizes.
Okay.
Right now, we're saying it's all sizes. So the other reason why it's all sizes, the board would have to make that determination whether you're going to waive that requirement. But then the applicant really won't know what to have as part of the application. So right now, we're saying it's 1,500 feet, between 300 and 1,500 feet.
Okay, of the wind energy system foundation is to be crossed out.
And it'd be the property line.
Okay.
So right now, the public policy is we alert everybody. We put the turbines, if you're putting a wind energy system in, we alert everybody. You have to, by law, within 300 feet of the property line. And you're going to go out another, you're going to go to 1,500.
But this, the way, excuse me,
Yeah, Doug.
the way it's written, we have latitude anywhere between 300 and 1,500? Is that right, or are we going to just say it's 15?
It's be 300 to 1,500 feet for everybody. Whether you're a small energy system or a large one.
Okay.
At this point, it's the definition. We're changing to this. We can have that policy discussion about who you're going to apply. So right now, we're saying 300 to 1,500.
More than fourfold increase, it's a pretty big increase from 300 to 1,500.
That's what I heard last time we talked. You didn't like 1,000, so.
Yeah, no, okay.
Then you upped it to 1,500.
Paul?
The public outreach area is irrespective of the size of the turbine, the way it's defined. Why do we have a minimum?
300 feet is required by state law. You
I mean,
have
they're
to.
going to be included anyway.
Pardon?
Theoretically, you could have a thin sliver of property coming alongside, you don't have to notify them. It doesn't make any sense to have a minimum. If you're going to notify everybody within 1,500 feet, just notify them within 1,500 feet.
The difference is here that it's by regular mail between 300 and 1,500 feet. Between
What is-
ground zero and 300, it's a difference.
Certified mail.
Right, from the property line to 300 feet out, everybody, all the abutters to abutters, that 300 feet, get a certified letter. Okay, and they have certain legal standing. They have a rebuttal presumption of standing in a court. What we're doing is going from 300 feet, 1,500 feet, sending someone a letter saying, well, you're invited, but like Richard said, we didn't want to implicate anyone's party interest standing. We're talking about the public outreach. So right now, we've got it at that area between 300 and 1,500 feet. And we can discuss that some more. So we got rid of the 4 times system, which we felt made sense. The smaller the turbine, the smaller the outreach area. The larger the turbine, the larger the outreach area. But we're finding some legal and some practical difficulties. That's where we are with that.
Okay.
More on that later.
All right. Anything else on the definition section? Okay, hearing none, then we go to the applicability and exceptions. I don't see any changes there.
Under
We
your
added that
application
language last
requirements,
week.
we talked about this at the last meeting. We would like the applicant to provide a copy of the application with the interconnect. So they have a real project, if they're going to be using
Doing the outreach, you're concerned about
using this.
understanding.
Be part of that.
I think it's in there, so I showed you that from last week.
Do that and liability insurance. And importantly also, documentation with regards to control of the project site sufficient enough to allow for construction. Do they have the ability to cross private ways? Some of these things can be fairly big. And the others are pretty standard under site plan details, just tighten up the language. But we did add a copy of the interconnect agreement as part of that mandatory pre-application need to see whether or not this is something that is a go with the utility company before they bother the board.
Okay. Any questions on either the applicability exceptions or the application requirements? Or questions or additions or whatever? Site plan details is pretty comprehensive. Comments or questions on any of that? I mean, I know you've all read it, but do you have anything you want to?
Again, take your time because we're going to be discussing it again next week. And this is the bulk of the stuff that's going to be coming at you. We're going to be making some additions at the end here with regards to the financial surety and the bonding it, and public inquiries and complaints. Trying to keep it below 8 pages.
Yeah, that's going to be a comment of mine. It's getting long.
It's getting long, right. So we're trying to, which is why you can see we're doing the Deadwood. You know, we don't need to say, it shall not be erected, constructed, installed, or modified. We'll just say constructed, modified. Start to cut out the Deadwood. So, go back on some of the legalese. Although some of the legalese is very important.
Okay, then we'll move on to the procedure for review.
Before
Do
you
we have
go,
engineering?
Engineering,
Wait,
yeah.
somebody had a question, Paul?
yeah, before you go there, on application requirements, that's the first time the SPGA is entered into the bylaw. Shouldn't that be in the definition as well? Because I believe it is this planning board, is that correct?
Okay, you need to be specific about where you're talking about.
Second line, application requirements.
Second line of
SPGA.
application requirement.
SPGA, that's the first time that's introduced. My understanding is that is the planning board, is that correct?
Yeah, it is, yeah.
Well, then it should be defined in the definition.
It is. It's defined under wind energy systems, special permit granting
Which page?
authority.
The very first page.
Oh, I missed it, sorry.
Right.
Right.
Okay? All right.
So we're on to
It's
engineering.
okay, pardon?
We're on to engineering then, number 4?
We're over to procedure for review on page 5.
Let's get page 4.
We skipped 4.
We get into engineering details and operating details. We've got a lot of information.
Yeah.
for consideration.
Right, that's all under the application requirements. I asked if there
Well,
was any other questions about that.
No,
one
it's-
said anything.
Oh, I thought number 4 was the engineering details.
Engineering details under application requirements. Go ahead, Doug.
Oh, okay. Well, I see that he did include the certifications now, that's good.
Right, what we did is, for your information,
Mhm.
do you have any certifications? And we've added several of them, for instance, parenthetically.
Mhm.
This council, that council, this association, these other state agencies. Give us what you have in terms of certifications. So it's a information package for the board. You're not actually compelling someone to go to the small wind certification.
But it's a great time to bring it up if they have it.
There you go, and I think that, not addresses, but at least answers some comments you had, so we thought how to do it.
Right.
And put it in like
It's
that.
good.
So by saying that California, mentioning the California Energy Commission and the New York State Energy Research and Development Authority, I'm assuming that there is no Massachusetts entity that could provide certification.
No, this is just for example. You see certifications, if any, of the wind energy systems shall be met, for example.
Okay,
Right.
okay.
If they have a Massachusetts entity, not something. But we just have those for.
Okay, got it. Other comments on the engineering section of the,
Yeah, what happens if they can't cite any certification?
We're using
Ask them why.
we're using a machine that has 0 certifications from anybody on God's green earth, and that should set off fire control right up.
and we probably,
So it is a requirement that it has to be certified.
But we're not saying that.
Yeah.
But it's a
Yeah.
concern of the board, if it's some things coming, that they're coming in, they may come in with a technology that's so new or avant-garde that they haven't had time to do that, that might be their answer. But there's a red flag for you, without compelling someone to use a proprietary technology.
okay, other comments on Doug?
One more comment about the sound analysis. I think it would be important to have both season, summer and winter included.
Okay, we're down to operating details?
I was just,
Yeah, I'm going to ask the board that when you pose a question or a comment, that you refer specifically to the paragraph and in the document, so that we're
Okay.
all on the same page while you're discussing your point.
okay, so I was referring to 5B, the sound impact analysis.
Okay.
And I just think we should specify that we'll do 2 seasonal measurements, one in the summer and one in the winter. Don't you think, or is that too much?
I agree.
Yeah, we're trying to be as generic as possible. Let them come back with their charter map indicating their expected decibel levels at given distances at the property line, daytime, nighttime, specify the conditions under which your ambient levels have been measured, and let the board at that time ask the questions, well, when were they taken? Do you have a seasonal variation? Let your expert, because you have the ability to hire one or have one here, opine on that sound study. I don't want the board to get into, you shall do this, you shall do that. Let them come back and tell you, oh, well, gee whiz, we took it in August and we took it in October, and that's good. If you don't like that answer, you could have it here. Let them come in with what they have to say.
So you're,
That's
Doug,
fine.
Doug, you were referring to 5B1, I'm sorry, yeah, 5B1?
I wasn't actually, I guess so. I was referring to actually potentially 5B4, that it shall be
Oh,
adding another line
add a
saying
form.
that, it seems like, it seems it should be done in winter,
Yeah.
but I don't know.
Well, all right, let me tell you what, let me talk it over.
Maybe the way you worded the certification option, maybe there could be a similar type of wording for this, that it's preferable to have both seasons tested if possible, or something like that.
Right, under various wind conditions. Let me see how we can address some of that in there without dictating procedures. We want them to be able to say, we use, like I said, we use the rational method, or we use technical release 55, or we do stormwater control methodologies. There are various methods to determine the amount of water that's going to flow at what rate to a given point. Engineers use various equations to do that. We tell them, under your rules and regulations, you have to use technical at least 55 or equal, or demonstrate to the board that you're coming up with these stormwater calculations, and then our PDs review. Same thinking here. Give us your analysis, tell us how you did it, how you come up with these numbers, what conditions did you apply it. We took traffic counts in July, and we took traffic counts in January. I'll be right with you, Rich. Go through help. Same thinking is there. Okay, traffic engineer, how did you adjust seasonal variations of the traffic counts you took in January for the new burger diddle you want to open up on T-Ticket Highway? And then the traffic engineer has to say, well, we used, Mass Highway Control Station Y over on Burke Hill Road, took 5 years worth of data, extrapolated it to equal what we think is going to happen here in the year 2004. We can nod and say, okay, that's okay, or we can say, no. So we're not telling them, go use Control Station 5 on Burke Hill Road and give us, see what I'm saying?
Yep.
So we do it for stormwater, we do it for traffic, and we kind of have the same approach and logic here. But let me see how we can
Maybe if you
squeeze it in.
can lead them a little bit, maybe they'll want to do it.
See how we can squeeze it in.
Right.
Yeah, Rich?
Thank you. Getting back to 5B1, it says ambient sound levels under, and the word typical daytime and nighttime conditions. But shouldn't we also be concerned on worst-case scenario?
On what, Rich?
Worst-case scenario.
Worst
not
case
just
scenario.
Typical, but what is it, the worst that can happen, and for how long could that be? I mean, if you said typical, so, okay, 200 days out of 365 days could be considered typical, but if there is 100 days when they're atypical,
All right, that's why we get into the specification of the conditions under which ambient sound levels were measured, as well as frequency and duration of these measurements. You want your typical conditions, your average conditions, your 80th percentile condition. I don't know if you want to know what happens in a Category 5 hurricane. That's probably a worst-case scenario.
No, but-
I just need
but if there are differences between winter and summer when the air is thinner and thicker, that might well be significant and
Again, atmospheric conditions are something that these acoustical experts have to tell you when they measured it, how they measured it, what they came up with. I don't want the board to be in a position of saying under your special permit rules, you must measure during whatever conditions. And let the experts go in to show you what they did, how they got there, the answer they came up with. Remember, you're going to have your own acoustical expert looking at these. So you don't have to be, like I always say, you don't have to be the experts. You have to be the jury.
Anybody else have
But let me
comments?
see again, seasonal variations, meteorological conditions. I don't want you to get into the minutia. I want you to say, you want this analysis. We want you to use your best professional judgment. Remember, we're not hiring. Welcome. This person who comes in has to demonstrate their expertise, and then they have to demonstrate how they came up with their numbers. Again, just like when the traffic engineer comes in and says, the burger diddle on T-Ticket Highway, no traffic impact. Of course, that's what you're doing. Of course, you'll get a second opinion on that study for your consideration as part of this application.
Pat?
Ralph?
I just think that, I do agree with Doug. If we're specifying ambient under typical daytime and nighttime conditions, I think we should also put in seasonal. Because I just don't like the idea of leaving it there. We know we're gonna look for it. Why do we want to do a gotcha? I just don't like that.
So let me see how we can get it in there.
Please.
Ralph?
Bob?
Wouldn't the Met Tower data take care of a lot of these questions? If it's over a year, if it's required for a year?
You read my mind, I think, attach the net tower data, or how you can move that information, show the board how you use that information to utilize it for your sound study. Let me see, if it's a concern of the board, let me see, just like with the certification process, I'm sure there's a way I can put it in there without dictating. We want you to be able to upfront voice your concerns, but we want them to have the flexibility of giving you information based on their expertise and not your concerns.
Rich?
Yeah, I just want to point out that when we look at 5C, 5C1, you're talking about seasonal differences, which means we're going to be talking to these people about giving us seasonal measurements anyway. We're going to have to be doing testing in different seasons, so we might as well require them to test for sound while we're requiring them to test for flicker.
I hear everybody, in this
Okay?
1, 2, 3,
Okay.
4.
I'm just trying to be
All right.
consistent within the framework of the regulation.
Yeah, right,
Fine.
that's fine.
Okay. Other comments or questions about the,
Yeah, Ralph.
yes, ma'am. The engineering details? Bob?
5 under operating details, B2.
B2?
B2, just a typo. Which ambient sound levels are measured, comma, as well as the
Are
frequency.
measured instead of measures?
Yeah.
Okay.
Yeah, I'm being a Ralph about that.
Got it. Other comments on the engineering portion? Okay, Brian, do you want to go ahead with then the procedure for review there?
This is where we talked about the definition for your outreach area. Under procedures for review, you see that word "any." Right now, we're saying that you're going to have that's public outreach over and above what is strictly required for a special permit. And right now, we're saying it's for any wind energy system. If people hear, while putting in a 10 kilowatt here, they, no big deal, they won't be here. But it might be that, oh, they're putting something in my neighborhood, I'm very interested in what's going to happen. I can come to the first meeting, I can look at what's going on, I can make a determination, whether to the second, third. It's 44 cents per mailing, at least it is right now. I think it's a wise thing to do.
All right. And then criteria for review?
Parties of interest.
Right now, again, we're saying for any wind energy system. And the reason we're taking out the differentiation between small and large is for what's known as uniformity issues. It might be that a small 10 kilowatt or whatever it might be, you won't apply the standard, but you're going to apply them, right, just as we do for the public outreach area right now, all these standards apply for all turbines. And what we're saying now for a height, before we were saying was be measured by manufacturer's standards to reach the performance of the nameplate capacity. Again, because it's zoning, we've decided that the maximum height, it's 200. Right now, the 100 kilowatt turbine on Woods Hole Road is about 120. And right now, the largest you're going, there isn't a 200 out there. If someone wants 200 kilowatts, they have to put up 2 100s. So why would we allow something that goes 400 feet high? In fact, you're never going to get that. So we're saying, come to us and show us what you want, but you can't exceed 200 feet. And it might be industry standard manufacturing to reach the rated name, the optimum based on your wind studies, but we're saying that's the. So that's a policy change for your consideration. That's what we're suggesting at this point as its town scheme. You also asked us to be more specific in why we have a safety setback. So we included the ice thorough mechanical failure. You also included, and you do this for certain special permits with regards to, I think we have it in senior care. I think we had it in your special permit for a planned residential development, and I'll find the other examples for you that you could require a large use setback. It's for some of those fail-safe provisions that we put in a lot of bylaws for you. And in some cases, I know your special permit can relax that, but we're not doing that here. So some of them are fail-safe. We have the sound setback, and that's your safety setback is your 110%. As all as your line in the sand. You can't get any closer than that. Even if your sound study comes back and says you can walk up to someone's front door, you always have to be that 110% of your system. Your sound setback is from your sound impact analysis. Right now, we're using the A-rated 10 decibels over ambient at the property line. That's the state standard at this point. And we also put in the pure tone. I'll find out exactly what that means for the 3 A-rated decibels. So I have precise information in front of me. We put the burden of proof, 5 minutes. We put the burden on the applicant up front for a statement of review. And we also put in that the analysis by qualified acoustical expert to show that you can meet the standard. You may waive all these requirements if someone comes in with a very small turbine. That's at your discretion. Then we get to clearing and design standards, but obviously folks want to talk about sound setback.
Mr. Chair.
Yes, Rich.
Yeah, with regard to this 2BI, one, I guess that is, well, I have a problem with requirements of proving a negative. It is virtually possible in many instances, if not most, to prove the negative. You could have a standard of proof that is rigorous, but, a standard of proof that requires the applicant to show that the technology and the installation that he's proposing meets all the concerns that are being addressed, as those concerns as may typically or normally arise, but to prove that something will never happen, that no adverse events will ever occur, that which is the way I read that, will not have a significant adverse on the adjacent land uses.
Well, the theory there is that when you have a heightened level of review, and it's a significant adverse impact, we're not talking about no impact. The state for ACECs, no adverse impact, is trying to prove a negative. Almost impossible burden of proof. What we're saying here is that the burden of proof is on the applicant for a significant adverse impact on adjacent. So you have to show a significant.
Where do we define that term?
So it's got to be there can't be such a numerical formula-driven answer to that question.
But it has to be.
Because, hang on, let me finish. Because your range of applications can go anywhere from 10 kilowatts to 100 or 200. Your topography, your site characteristics, to have a formula-driven bylaw, well, you don't need an SPGA to make these determinations. You just plug in the numbers in your equation, turn the crank, and there's your setback. So there has to be a real review by a real board with real information to come up with a real answer. It can't be a formula.
but there has to be a threshold definition of what significant means. And without that, then you are creating, look, we're seeing this, I will say we're seeing this in West Falmouth. There are many people who have complaints, and I'm not saying they're not legitimate complaints, but there are many other people who have no complaints at all. So the test that I would be looking at here is, where do you draw that line in terms of those differences? Because the people who have complaints, believe me, they think this is significant. And the people who have no complaints don't. So we have to have some kind of standard, some kind of quantifiable standard. If you don't have a quantifiable standard, then you're talking basically arbitrary and capricious review. So,
All right,
Any
well,
other
I don't think I'm going to be able to come up with a numerical formula-driven definition of significance. It's virtually impossible. So I'll try to find a different terminology.
well, may I make a suggestion? Is if these people are doing these tests on these things, objective testing of large groups,
Okay.
and to just simply say, you prove this by saying, well, we've tested this with a sample of 1,000 people here, 1,000 people there, we find the incidence of objection to be lower than, you pick a reasonable percentage, lower than 5%. You know, if you're getting up towards 20 or 30% objection, now you're talking significant. If we're talking levels of objection among actual test populations that are down in the single numbers, I think you're talking insignificant. Or at least that's a reasonable way of defining it.
And that might be something, 20% might be significant for you. It might be insignificant for Doug. It may be very significant for Pat. It may mean nothing for us. Jim could have no opinion, but that's why we have 7 boards to weigh what is significant.
Wait a minute. If it's talking about, it bothers everybody 20% of the time versus it bothers everybody 5% of the time, that's one thing. But we're talking about is, how many people does it bother at all? And if we're talking about it only bothers 5% of people out of, you know, that'd be like 50 people out of 1,000, I think we could say, we could make a determination, as a matter of public policy, that's not significant. If it bothered 200 people out of 1,000, I think we could make a public policy determination, that is significant.
I'm going to ask the board, I'm going to ask the board at this point whether they have an issue with what Rich is talking about, and that's the word significant in looking at in criteria for review, number 2B1. Does anybody else have an opinion about the word, using the word significant? Rich, yes. Bob?
I think it gives us a little bit of wiggle room. Having it not defined to a specific number allows us a little more latitude in a decision on that.
Jim?
I agree, it's specific if it's, you're the one that's bothering, so I think I'd like to have all the latitude we could on listening to people and not tie it to a number that could rule out.
So you're
I like the way it is.
okay with the word significant?
Yeah.
You are too.
Without further definition.
Okay, okay. Anybody else with an opinion one way or the other?
I'm fine with it the way it is.
Okay. Well, it appears that the board, even though Rich brought up, I think, is a legitimate point, it appears to me that the board is comfortable with leaving the word significant in there, at least at this point.
That's fine.
Okay.
In the background, I'll be working on that some more, to think about what else could we substitute, or what other guidance you may have in there. But that's why we have 7 people up
That's
here
right.
to
Yeah.
make a determination whether this is significant.
Mhm. Okay. Go ahead, Brian.
I know.
I'm thinking like a lawyer, how I'm going to bring this, some lawyer's going to take the town to court over this, for being,
I know.
denying a permit because you didn't define significant.
Oh, you can, they can be number 32 in line.
I'd like to move ahead.
I understand. I'll be working in the background a little bit, so we don't have any kind of findings. But that's where we are on sound and safety, that's where we are on setback. Okay, we're doing a safety setback, we're doing a sound setback. Clearing is pretty standard. Your design standards, again, we got into some of the information that you wanted in regards to education. Under your safety and environmental standards, again, we asked them to provide a copy of the emergency services plans and coordinated with Falmouth Fire and Rescue. The response plan has to be approved by this board. And we added the response plan includes any hazardous materials on the property necessary for the operation of the wind energy system. And again, we have the access standards. And right now, we've got the shadow flicker standard of 30 minutes per day and not to exceed 10 total hours per year at the property.
Okay. I would like to stop right there.
Yeah, okay. That's what I said. We also have the same burden of proof of significant, the applicant has the burden of proof to demonstrate that there will be no significant effect on flicker, so I'll have that same, I'll do that same thinking with regards to that language here as I am over on the side.
Okay. I would like the board to address a concern that I have about shadow flicker, and I want some opinions from you all, if I can get them. I am not in favor of allowing any shadow flicker on any residence at all. And that is because I have observed shadow flicker in turbines that exist here in town. And on buildings and on structures and on parking lots. So I understand that shadow flicker could be perpetrated upon a highway or a street. And actually, shadow flicker occurs without wind turbines when it passes through trees when you're on a car, when the sun is low. So I'm interested in to what degree this board is willing to allow shadow flicker on residences here in town. So I'll start with, okay, Rich?
I would simply put a cap on it in terms of number of minutes per day, and I would not have a zero tolerance, policy on that.
Okay. Doug?
I'm not sure I know enough how that would impact. Would that possibly be like prohibitive to where there would be no more turbines? I'd have to give that some more thought before I say. I think there's going to be some flicker from some of these in the wintertime. It's casting such a long shadow. I don't see how we could really avoid it at all.
I'm not saying there won't be shadow, I'm not saying there won't be flicker. I'm saying whether or not there's going to be flicker on residences or buildings.
That's what he's saying.
Well, yeah, that's what I'm saying. I think it's inevitable there will be some at some time with all the different angles of the sun and the low angle of the sun in the winter. It seems like really, to say 100%, I think it's going to be nearly impossible, or it may make it impossible to site any turbines. But I don't know enough to really say that.
Yeah.
I'm
Pat?
afraid of that.
I rather think it will be impossible, that the only way it can be controlled is the way I understand Wood's whole research is, that the resident complained and they turned the turbine off when they calculated that it will cast shadow flicker.
Right.
And I think that is the only way that it could be controlled. There will inevitably be flicker. Is it going to drive people crazy? I don't know.
That's what I don't want to happen.
Mm-hmm.
Yes, Paul?
I think The size of the turbines we're talking about here reduces the amount of shadow flicker. I've worked in an office near the Notice Energy. At certain times of the year, there was shadow flicker on the building. I was on the opposite side, did not affect me, but people who were immediately opposite that were impacted, maybe for 10 minutes, and the office put up shades. So even a turbine that large was handled fairly easily. But I think the size of the turbines we're talking about minimizes shadow flicker for the most part.
Bob?
I would think you'd have to have some sort of dimension that would determine how far that shadow flicker would go, and I think that's nearly impossible. I think the best thing we could do is set some sort of standard like we have here.
Jim?
I don't believe one property owner has the right to inflict anything on an abutter's property that's solely for their benefit. I think it's a property rights issue. I think if they can't control the flicker, they shouldn't be allowed to put it up.
So the only way to control it would be to shut the turbine off for
Well, they
that-
time
for
it now.
that
I mean,
time?
yeah, they
Would
take
you-
it,
would you-
yes,
would
yeah,
you
they
be
have,
agreeable to that?
if they're not producing flicker, yeah.
Mr. Chair, as Doug has
yeah,
said,
Rich?
as Doug has said, there are seasonal variations. You can have a house which in the summer, when there's full foliage, is sufficiently far enough away from this turbine that no shadow gets to it from this turbine because the trees and the angle block that. But then you come into the wintertime, and when we have good winds and we have, production of a lot of energy, and the foliage isn't there to block the shadow. So Doug, I would go to an objective standard as to what is significant in terms of minutes per day as being the maximum allowed. And as for Jim's concern about one property owner using his property to the disadvantage of another, that's why we have nuisance laws and lawyers and lawsuits. And that is a perfectly adequate remedy for that if it should, I don't think we should be the ones to make that determination ahead of time. It may well be that there are people who are very comfortable with having that shadow flicker on their house, can make, as Paul says, easy adjustments, shades, and they don't mind doing it because they support the idea of getting their neighbor getting that cheap energy and sticking it to the oil companies. Many people feel that way. If somebody doesn't feel that way, they feel opposite, they can file a lawsuit and get damages. I don't think we should be getting into that with zero tolerance policies. We should set reasonable standards that are measurable.
I totally disagree with you. I feel as a bylaw should be as comprehensive as possible to avoid litigation and protect property rights without having to go to court. Doug?
Maybe during the process, we'll know how much flicker from the projected analysis, and we'll have some idea of the homes that will be impacted, and we'll see how those residents feel, and maybe there'll be tighter standards than this 30 minutes per day. Maybe we should sort of reserve the right to let the impacted neighbors voice an opinion about it somehow.
Okay. All right. I said I got opinions from the board on that, and I appreciate it. Brian, was there anything else under safety and environmental standards that you wanted to bring to our attention?
I think it's all pretty self-explanatory. We tried to incorporate the other ideas you had about hazmat response with the fire department. Put that in there.
I had mentioned last meeting that in some of the research that I had seen that there were references to not having any, I believe it was called electromechanical interference. Let's see if I can find it. And I didn't see anything included in ours about that.
We're still doing a little research on
Which
that.
was, I'm sorry?
We're still doing a little research on that.
Yeah.
Because everything's digital today. We don't have analog TV. No one has an antenna anymore.
All right, let me see if I can find it. Let
It's necessary.
me see if I can find my reference to that. believe it was called electromechanical interference. Does anybody else remember what I said, how I talked about that?
You were worried about radio and television interference, and we're still looking at that question for you.
Okay. I don't know why I can't, give me another second. Yeah, there it is. No electromagnetic, that's what it was called, electromagnetic interference.
We're still
Okay.
looking at that.
Okay, fine. That's all I wanted for you to
No problem.
include.
We
Okay.
think you're going to be okay.
Yes, Rich?
Yeah, jumping ahead to 4A. under,
4A, we're going
under-
backwards then.
No, I'm talking about going ahead to standard conditions, for.
Give us a page number to start
Page
with.
7, page 7.
Well, we're not there yet.
Well, I just know this gets back to this flicker issue, because this is your answer to it right there. The building commissioner shall be responsible for enforcement provisions of this section. A failure of the owner to comply with operational standards, mitigation measures, or annual inspection requirements will be considered a violation of the zoning bylaws. So you don't even need to file a lawsuit. If we set a reasonable standard, a reasonable doable standard, like 30 minutes a day maximum, no more than so many days a week, if that's easily proven to the building inspector and the owner gets whacked big time with fines. We don't need to set zero tolerance standards here. We can set reasonable performance standards, and the building commissioner can enforce them without need for major lawsuits, major litigation.
You're on page 7, and where are you? What paragraph and what number?
4A.
4A.
So if we just establish operational standards and mitigation measures for the issue of flicker, then the owner will violate those standards at his peril,
Okay,
and it can be easily enforced through a complaint process.
okay.
And on the other hand, if somebody doesn't mind it, if they're experienced to it, and they don't mind it, they don't complain, well, what's the problem?
Okay. Brian, let's see, down to standard conditions at the bottom of page 6.
These would be your standard conditions you would place on most wind energy systems regards the maintenance of the facility's condition. Right now, we're saying for large systems, an annual inspection. Modifications require, coming back to this board, Richard indicated the enforcement and penalties is your standard under the state law of the building commissioner. I also want to make sure you fully understand that once you issue your permit, the board is not an enforcement board. You're not an enforcement agency. So you apply these standards at town meeting, finally votes, you issue your permit, but always remember, any enforcement actions go to the building commissioner. Any appeals of his decisions to the zoning board.
Okay.
Ralph?
Yes,
Where are
Bob?
we at?
Sorry, just,
Go ahead. I just wanted to go back to 5C on page 6 about shadow flicker. One of the last...
5C on page 6?
Yeah, shadow flicker. We're talking about shadow flicker on about his property, but it says right there that it shouldn't exceed 10 hours per year at the property line. So we're saying that the shadow flicker doesn't go beyond the property line.
What? Correct.
Okay. And then also, too, I was curious about duration. It says 30 minutes per day. Is that a 30-minute duration, or could that be?
My understanding is it's a 30-minute duration.
So that would be the longest period, any given duration, okay.
I think Bob's concern there could be easily cured by saying at or beyond the property line.
I'm going to go back, I've got that noted.
At or beyond the property line, because what happens on the property line or up to it is the owner's concern.
Right.
But you may have a building such as notice, you may
That
have
would be
properties
on.
on the property, and we're saying is like, it's 30 minutes a day. So let me make sure that the language is consistent. Good.
Okay. All right.
Then you have the language you asked for, Paul, with regards to abandonment and decommissioning. You inserted now. And we're still working a little bit on the financial surety portion of it. One of the tricky issues is rights of entry. So I want to consult with counsel on that. I'm not sure we can compel a right of entry. You know, under the zoning bylaw, we have a surety. We require a bond for the landscaping on someone's property. It's on a condo development, and they want occupancy permit, but it's winter time, and they can't do their planting, so you can receive a bond to insure it, but you don't have a right of entry to go to the work. I'm not sure whether it can be compelled here under the zoning bylaw either. So right now, it shows a right of entry. I'm still doing a little research on that. In the last paragraph 7, public inquiries and complaints. That's not the end of it. That's where we stopped to get this out to you yesterday, so you can at least have it a good 24 hours before tonight's meeting. I think that might also help with regards to enforcement and recognizing compliance with your conditions. So those are the 2 last sections we're working on. Again, this whole package is subject to your discussion in the next few weeks. But as you can see, we're reaching a point now where it's starting to crystallize and starting to come together. Pretty much, I would think with the next few weeks, we're ready for public comments. Then work on it some more, and then make a decision whether we want to bring it forward to the board.
Okay, so then before we go to ask for public comments, we need to get this available to the public. So it would be in draft form. Would it be available on the on our website?
It's always available to the public as a public document, but I think we need to work on it some more before you public comment.
No, I understand that. Okay. But once we've decided that we want to put it before the public,
yes.
Is there a way we can do that electronically without having to have the public come into the office and get a copy?
Email it to folks and put it up on the webpage.
Okay. Rather than email it to people who ask for it, can we put it on the webpage so everyone will have access to it?
I don't really like doing that because it's changing almost all the time. We get a static one there, but most folks who are interested in this call the office and ask for the most up-to-date copy of it. We've had, since the last time we talked, since June 20th, I think there are at least a dozen versions, because we work on it every day. So I would rather not do that one.
I know, but a version, I would think, would not be available to the public until after it had been presented to us. Like, for instance, tonight would be the 4th version. It wouldn't be the 5th or 6th version while you're working on it during the week.
Oh, I see. Okay, so put this up on the webpage. This is the last one you discussed.
The most recent one that we have discussed,
That's fine.
then I would think that would be appropriate.
That's okay.
Yeah. Doug, did you have something?
Rich is ahead of me, but
Rich?
I was just wondering why this right of entry couldn't come under something similar to what we do with derelict buildings, condemnation.
It might have to. It might have to be the building board.
So we'd have to have a new bylaw that would specify.
You might have to go through another entity.
Yeah, okay.
Right, that condemns it and puts a lien on the property. It may not be this one.
But we could get that done one way or another.
That's why we're looking at that. That's why I mentioned to you that this right of entry, more than likely, this is going to work for you. It's probably going to be something like just like you suggested. I'm not sure whether that's possible, but we're looking into it. Good.
Doug?
No, I was going to say that same thing. Bob's ready to go.
Yeah, Bob?
Ralph, rather than put a stale document on the website, wouldn't it be better if we just said, if you want a copy of the latest update, contact the planning board office and have it, and you could then email it to the interested parties? Would that work, or is that?
You can do both.
Yeah.
We put it up and we're working on it. It's not a public what I'm working on is not a public document.
Okay.
It leaves the office.
Okay,
This is obviously not a public document because we discussed it here in public.
yeah.
So I can put this up and earlier versions, certainly are public
Okay.
The only thing I have that might be in opposition to that, Bob, would be the fact that every time there's a phone call to the office, there's an interruption of what the work that they're doing, that's all. Yes, Paul?
I just had a question on page 7, item 4.
Page 7, item 4. Yeah?
I understand this is a bylaw, but we are introducing the subject of enforcement and penalties. Would it make sense to talk about the enforcement procedure here rather than enforcement and penalties? Because we don't even broach the subject of penalties. And something like the SPGA has authority, defers to the building commissioner for implementation or something, or some kind of process showing how you would go, how you would object to someone who perhaps violates this particular bylaw. I know that we're getting into a gray area by doing that this is a bylaw, but it is approached here as an enforcement item.
Right, and there are other sections of the zoning bylaw that spell out procedure and how enforcement actions are brought. You don't have to replicate it here. We might just put that section in for you. The building commissioner is the responsible enforcement agent. And there's other sections of the bylaw that dictate how those complaints come in, how they're handled, the time frame he has to respond, and any appeal of his decision. So what I'll do is let me do a reference to that other section here.
Procedure sheet.
Did I answer your question, Paul? Did I answer your question, Paul?
Thank you.
Okay, yeah, Rich?
Yeah, I think that one way to say the building commissioner shall, upon complaint or his own direct observation, be responsible. So that would specify how it gets done. It can be done either by him making observations during inspections or otherwise, or receiving complaints from the public.
Let's spell that.
Yeah.
Let's spell that out.
Well, that could be put in there, that's how he does it.
Right, I'm going to want to reference that other enforcement section.
Yeah.
Okay.
No, replicating.
All right, that pretty,
So, no other questions?
Scott, I was just going to say, that pretty much wraps up our review for the bylaw tonight.
All right, so let me I just want to go back, you want to copy this up on the webpage, reference the other section on the enforcement penalties. I'll go back and look at the word significant, make sure the language is consistent with shadow clicker that would mean adjacent property. Significant for the sound study level of proof. We wanted to try to get the atmospheric and seasonal variations into the sound impact analysis. There's a typo for injury there.
Bills period.
Otherwise, let's see, we want some information on why we're testing for pure tone sound and what are we talking about. So very good, thank you.
Okay. I would think, Brian, that rather than publishing this, that you, on the website, that you would address the things that we brought up tonight and then put it out. Because if you put this out, it doesn't tell anybody who's reading this that we've discussed all of these things and made suggestions for changes, et cetera. But then again, how soon can you do that? You know?
Right. which is wise. Let me see how quickly, all I'm going to do is put this up on the webpage. This is the latest version discussed by the board. There will be further changes based on those discussions.
That's fine. And you might also suggest to the public that they could review the FCTV portion of this meeting, which would give them the information that we discussed about this particular copy. That might be a thought. Okay? Anything else on the bylaw? If not, then we're going to move ahead with our agenda. The next item on the agenda is the general residence, section 24026C of the zoning bylaw, which was a request by Jim last week concerning that particular bylaw. And there is a section of the bylaw, and there's a copy of that in your folder tonight if you didn't bring your book. Jim, would you want to comment on that?
Yes, section 240-24C in the general residential district allows by right a homeowner or developer or anything to build a third unit.
Excuse me, Jim, I'm going to interrupt. You said 240-24C, and it's 240-26C.
This is printed,
240-26C.
and this handout tonight has the wrong,
Yeah, but you got to go to the back page. You got to go to the back page. Here.
240, section 26C,
It's upside down, I think.
multifamily dwellings
Here
of
it
3
is.
units.
okay,
240-26C, and I've got it right here if you want to use it.
okay. I was reading from the handout
I
here.
know, that's, here it is right here.
Okay, 240-26C, sorry. It allows for by right, which means you just design your building and get a building permit, there's no hearings. You can put 3 units up as long as one of them's affordable. And something happened recently on one, I actually did this twice. I built 2 of them by right, and recently the town, I had to record a 12-page document restricting the property forever as affordable, and I had to sell it through the Housing Assistance Corporation to someone on their ready-to-buy list. They had to be qualified and income restricted. And a couple months ago, the town released the homeowner from it and turned what was an affordable, deed-restricted, forever property into a market rate unit. I had to sell it under one set of conditions to get a building permit following this bylaw, and it was explained to me that because I got a general permit to do something else on the property, it negated that deed restriction that I had put in place. And I listened to the explanation, it doesn't make any sense to me, but it happened, and I just don't understand it, and I really just want to make sure it doesn't happen again. Because I guess what people are telling me, that there's a flaw in the bylaw, the way it's written, that this, what I thought was done in perpetuity, can be extinguished by other activities, and that was not the intent by me when I built the property.
Where did that occur? Where does that appear in the law?
It didn't occur, it was, here's a release, signed May 19th by the town manager, releasing, totally nullifying this 12-page deed restriction that I had recorded and put in place on.
Who are the parties to the deed restriction?
At the time, it was me and the person I sold the property to and the town of Falmouth. The town of Falmouth had specific rights, such as if there was any windfall, or they had a right of first refusal that they could buy it. It's a long document. I paid a lot of money to have it drafted, 12 pages and recorded. Just recording it cost me a lot of money. And I did it to, and I built more than one of these too. There's other them out there. And the selectmen authorized the town manager to negate it. And I was told supposedly, because when I subsequently got a special permit for another unit in the building to use its office space, that because I didn't reference that there was already a deed restriction was recorded in place and the town required me to do before I got my building permit, they said that negated the thing and they took it away.
Get a lawyer.
That doesn't make.
Well, I
any
don't
sense.
have a horse in the race anymore. I've sold the
You
building.
don't have standing, but as a public,
It's a public issue for me. I do not own the
Yeah.
unit.
get a group of citizens to,
No, what I want to do is fix it so it
Action.
doesn't happen again. I was told there's a flaw in the bylaw that needs to be fixed.
well, yeah. but-
And I'm here to see if we can figure out what that flaw is
And
and
I
make sure
think
it
this
doesn't
should be
happen
fixed
again.
legally. There ought to be a way of fixing this legally, a citizen suit.
I don't want to. I want to fix it so this, if the bylaw's flawed, I think we should fix it. That's the purpose for bringing it up.
But is it flawed? I think you need to get a legal opinion on it. Is it really?
I was told it was,
Who told you that?
Well, let's let this
Several
one go
people.
and fix the.
Well, did a lawyer tell you
fix the
that?
problem.
well, I don't
Wait a minute.
want to get,
No, this is,
Wait,
I mean,
wait,
this is
wait, wait.
important, Jim.
Okay, hang on a minute. Okay, so Jim, you're interested in
we have a,
seeing whether or not this bylaw is flawed.
yes.
And I do believe that we have the opportunity to ask town council whether or not this is flawed, what could be changed in this bylaw that would preclude this from happening
And
again.
that's all I'm interested in.
Okay, so if that's, we have that, I do believe we have that, that purview. And if we don't, I'd like to know anybody on the board who thinks we don't have that purview, because in my opinion, I think it's a legitimate question.
We
being
sure
brought
do.
by a member of the planning board. So, Jim, I guess what I would like you to do is to propose the action that we take, and I'm willing to sign a letter or do whatever it takes, in requesting an opinion from the town council. So I need for you to say that.
I'd like to make a motion that we request an opinion from the town council as to what needs to be done to the bylaw to make sure this doesn't happen again.
Second that
So
motion,
you need
only
to
I
be
would word it.
specific about, please, you need to be specific
Specific about, okay.
you have to name
The
the
bylaw.
bylaw, name the bylaw.
Okay, 240, 25,
No,
240, 20,
It's 240-26C.
26C.
C, 24026C, as relates to the multifamily, having the third unit be affordable and deed restricted. And that should remain forever, and there should be no way that it should be for perpetuity, period.
Can I make a suggestion?
Okay, just a minute, Rich. I need a second for the motion, first of all.
Second.
Okay, now, discussion.
Okay, first, we need to have an explanation, not an opinion, an explanation from town council as to how this happened. Not simply an opinion, but an explanation. Where is it in the bylaw that says this can happen? Now, I would think a simple expedient for this would be that the language of the deed itself include the language that this is irrevocable and in perpetuity. Irrevocable.
It does.
Well, if it says irrevocable and it was revoked, that is illegal on its face. Sue them.
Okay, well, you can't say, you have to understand, Rich, that he doesn't have anything legally to do with this anymore because he doesn't own the property. So it's
Well-
a matter of this planning board, in my opinion, saying that this is an affordable unit that has been lost to the affordable housing inventory because of some action. And we want an information and opinion about it.
And I
That's
think,
what the motion is.
and I
The
think it would
motion
be,
is asking the
okay.
town council to examine 24026C as to the reason why this particular unit was deemed no longer affordable, and whether or not this bylaw can be changed to prevent that from happening in the future. Did I say that right or
Yes,
didn't I?
yes.
Okay.
I support, I second that. All in favor?
Well, wait, just a minute, Rich. Is there any other discussion on this?
I think it has to be referred specifically to that particular document, not in general. If you want to
Well,
specify
I'm
that.
sure that we will include,
Jim,
we will include this particular, you're willing to include this
Right,
information?
but I was given an explanation, and I was told that because this wasn't, you didn't use any government funds, and it was done by a private individual, that's why it didn't count.
Well, if that came from the town council, then we don't have to send them the letter. But
No,
you're saying that you were told that.
I was told that.
Well, unless you want to talk about who told you that, then we're going to ask our town council.
I want to ask the town council.
Who works for us when we ask for legal decisions from the planning board asks for legal decisions.
And I guess just a matter of clarification, when I applied for the building permit, I was told I could not get a building permit unless I put this deed restriction in place.
Okay,
And this
fine.
deed restriction was put in place before I got the permit to build the building.
Okay. All right, now, any further discussion?
Yes, I'd like to see that if I could, Jim. I appreciate
Well,
it.
you can see it after,
Yes, I understand
after
that.
the meeting.
I would think, Jim,
If he wants to
if
show it.
Jim,
It's a recorded document, I'll give you a copy.
if you have relied upon that representation to, in any way to your detriment, you might have a cause of action. If you have relied, if you were operating out of a spirit of public benefit, and you might have made more money by going a different route.
I'm going to do point of order
Yes.
because you're way out of
I
order.
know.
All right, now you're doing courtroom stuff
let
here.
me leave that one aside. Let me leave that one aside. Would not some agency interested in preservation and propagation of affordable housing that has, not have a right
We
to...
happen to be that agency, Rich. We have a housing production plan that was signed off by us and the selectmen. So let's just stop debating this. We've decided, we have a motion on the floor to send a letter to the town council asking questions about this. Now, is there anything else that's pertinent to that?
Essentially, we're asking him to find the loophole.
Close it.
Yeah.
And
All right.
That's
fix
all I
it.
want to do. I want to close the loop.
Close the loophole, yes.
All right, so
Absolutely.
what this will involve, before we vote, what this will involve is we've asked the staff to draft the letter, and I will sign the letter.
Can I chime in a little bit?
Pardon?
May I offer some input?
Sure.
I gave you a copy of the most recent version of this section of the bylaw, which is 240-26C. You'll notice that the legislative history is again, and it says annual fall town meeting, November 9th, 2009, Article 11. You see this?
Where is that?
What I gave
I don't
you-
have that in mind.
In your package,
It's,
No, I know what's in the packet, but I'm looking at my copy of the
It's not in
bylaw.
just take out what in your package, because we updated this back in 2009. So in your brown folders, you should have a copy of the general residence district.
That's what
Everybody
you.
got that? There you go.
I
Richard
think-
has it.
I think it's printed upside down on the back page, isn't it?
Darn,
So you're referencing the AFTM 119209?
2009. And at that time, at the town meeting, on your recommendation, we changed this section of the zoning bylaw. And you'll see that it says, multifamily dwelling with 3 units, if at least 1 unit is affordable as defined. And before, the language of the bylaw says, so long as you bring a deed restriction into the building commissioner, so that the unit is affordable. And what we found was that was a flaw back in 2009, that those private restrictions, such as Jim put together, which satisfied the bylaw at that time, weren't your standard deed restrictions approved by DHCD that would allow you to apply local action unit to put it on the subsidized housing inventory. So we changed the bylaw. Now you have to have a DHCD-approved deed writer together with a small regulatory agreement. That way now you've got the state involved, the town is party. I'm not sure the town signed the deed restriction. You're private. Right. So if we don't sign something, we're not a party to it. So if we're not a party to it, we can't enforce it. And the bank that wanted to refinance this lady's condominium wanted the, like all nervous bank attorneys, wanted the town to sign off. My understanding is the town didn't have standing on that deed restriction. So I think cured some of the defects back in 2009 with regards to the general residence district and these private deed restrictions. And right now, I think one of the flaws might be that it's a by right use for a triplex. And if you go in and change it from a triplex, that might be something that we'll have council look at that needs to be patched up, which is pertinent to the zoning bylaw, not a private deed restriction. So just a little information. I have no problem writing a letter to Frank on your behalf, saying that, you know, we want your legal guidance and opinion as to how we might cure this zoning defect. To make sure that, let's say, if it goes from a triplex to a duplex with an office, we still have some kind of handle. Or that, you know, if it's got to be a private deed restriction, that there's a predecessor and title stipulation, that even though you might have sold the building, it has to be signed off by you before any restrictions can be extinguished. So I'll be happy to form a letter on your behalf, but let's make sure, I think we kind of looked at that for like a year and a half or 2 years ago.
I'm not really interested in having myself sign off. I'm interested in having it stay permanent. I think because the only thing, I built one of these buildings, so I could go to those other buildings and get a special permit on it, and bop another one back into the market rate. There's a loophole here that needs to be fixed.
And if there's a zoning defect, fine. But I think the deed restrictions that need to come in now are as redefined under the bylaw. If you go back to the definition section, where we get into what is an affordable unit, you'll see there's references to 360 CMR 52, which is all the deed restrictions required by, which, can I just finish? It's a deed restriction that we have DHCD or mass housing a party to, the town signs, there's a regulatory agreement, you can get yourself on the SHI. It's virtually impossible then to get yourself off, even if there might be a zoning defect, because DHCD has to sign off as the subsidizing agency. Right now, there was no subsidizing agency with private deed restriction.
I did have to pay a fee to hack, $1,400 fee, doesn't count?
Doesn't. That's the Housing Assistance Corporation, it's a private corporation.
Okay, so it's because it was all private.
They're the monitoring agent.
Right.
But they're not a subsidizing agency. Mass Housing Partnership, those are the types of state and federal subsidizing agencies that give standing to these local action units to get out and subsidize housing.
May I speak?
So that's why we changed that back in 2009 to make sure that it's a DHCD deed writing, and that there are parties of interest in here, like the town and the subsidizing agency that gets you on the list. But as you state, if there's a flaw out there in zoning world, that you go from a triplex to a duplex and an office, that defect needs to be cured.
Yeah, Jim.
Yeah, well, it's funny. Normally, things are grandfathered. When we change zoning, things that were put in place before that don't get changed. They have a grandfathered status. This change in zoning seemed to go back and be able to eradicate a pre-existing agreement.
No,
Doesn't make sense.
If you have a 2006 private deed restriction, you can't go back and change that if you made a change to the zoning bylaw. In the future, if say you want to take advantage of that section again, you have to bring in the standard DHCD, survives foreclosure, all that, survives foreclosure, as part of a regulatory agreement, as a subsidizing agency, so it counts for on the SHI. That's the deed restriction he brings to the building commissioner. Before, back in 2005, when you brought yours in, we didn't have these stipulations. Today you have them. We can't go back retroactively on any private deed restriction, unless you go back and you're the private entity that has standing. So my understanding is that the deed restriction is not enforceable at town, but there might be a zoning defect that allows someone to come in and change things in midstream that knocks out that 3-unit, one must be affordable. So we need an opinion perhaps, or some guidance on how perhaps best to remedy that. But I think we did remedy the deed rider issues and whether or not these units can count on the subsidized housing inventory before they could with this private restriction.
So, but basically, we're saying that a private person can't do this anymore, it has to be government subsidized in order to get this.
It's always been a requirement to have a subsidy. Now, the subsidy might be like on a LIP project like we had here in Glenwood Avenue with Habitat for Humanity. We're the subsidizing agency because we, the town, are putting our staff hours and staff expertise as the subsidy.
Plus you're giving them the land, the town.
Yeah, that helps.
That's
but-
gotta be a huge subsidy, Brian.
Just- Don't let me, it's the state, we're dealing with the Commonwealth of Massachusetts. The subsidizing is the things that the town does, it's not a monetary thing. Right now, it's on the local initiative program, local action units, we become a co-applicant, and we're responsible for the monitoring. Financial subsidies are only the state and federal government. The town cannot be a financial subsidizing agency. We cured that back in 2009. We'll go back and take a peek at, is there a zoning defect?
Okay. All right, Rich,
Yes,
briefly.
I don't see where it makes any difference if it's the town that released this restriction. And so if the town had put money into it, they could release the restriction. Why wouldn't you be able to say, well, HAC is a private organization, and they get to benefit from the rider, a restrictive covenant rider? That they are as part of their review of this, they have an interest in it. Now, they are a private agency who has no other agenda other than affordable housing. And why couldn't they, like Jim said, he paid a fee to HAC. What if he'd been able to put them on the deed?
I don't want to talk about Jim.
Yeah, we're just trying to be in bylaws.
I haven't read it, but my understanding is a private restriction between he and the buyer, and the hack was the monitoring agent. But let's not go there. Let's talk about, is there a zoning bylaw, a public action that needs to be taken with regards to this section of the zoning bylaw to make sure that it's not illegal?
Okay, now,
What I'm saying here-
excuse me, Rich, we haven't voted yet. And
Okay,
I want
let's vote on it.
to vote on this, and I want to clarify one thing with you, Brian. Are you comfortable with signing the letter, or do you want me to sign the letter?
I can always just call Frank and talk to him about it, but I'll write up a memo for you.
Thank you. Okay, I will sign. Okay, any further discussion then on going to the town council for an opinion on this? Yes?
I'm a little concerned about the perception of this particular issue. We have a member of the planning board acting as a private developer, developing a piece of property under certain conditions. Those conditions apparently, although we don't know what the details are, were changed. And the explanation given to the member of the planning board was not sufficient. So based on that, we're looking at trying to address an issue with the zoning bylaw. We don't know at this time whether there is a problem with the zoning bylaw. We don't know what the issue was, and we don't have a lot of details. So I'm a little uncomfortable with this whole process and writing a letter without knowing what it is we're specifically asking for. If we can keep it generic, and I'm not sure you can, without referring to a specific case, I'm not sure where we're going to go with this, and I don't know if it's a good use of the planning board's time and energy to do that kind of thing.
Okay, I think that's a legitimate concern. And it's unusual because a member of the planning board was personally involved in the situation, and at which point, as we all know, if we're personally involved, we can recuse ourselves. And so in this case, the motion was actually brought forth by Jim because I asked him to do it. before we vote, I could ask Jim if he wanted to withdraw his motion, and someone else on the board could make the motion, and then Jim could recuse himself on the vote. It's a little tricky.
I no longer have an interest, though.
I understand you don't have to recuse yourself, generally speaking, if you don't have a financial interest. Isn't that correct, Brian?
It's 5 years ago. 6 years.
If it's just a simple letter to council with regards, I think I understand the issue. It's a very simple letter to council with regards to a possible law in this section of the zoning bylaw that might allow an applicant to escape the requirement of having an affordable unit after the fact by modifying his permits, public permits, so that the project is no longer a triplex as defined. Does that extinguish this affordable unit requirement? And that's something I think is legitimate. The bylaw might have to have some kind of language that says a multifamily dwelling of 3 units, if 1 unit is affordable and as defined, irregardless of any further actions that might, regards to the property. There might have to be some other definitive language in there that's is specific enough that at this point in time, you're a triplex, and that affordable unit is a condition no matter what might happen to this property in the future. That's a legitimate concern.
So as long as the letter doesn't reference this specific case, I think we're probably.
No specific case. I have that.
I'm sorry?
I have it certain here, no specific case.
No specific case, okay.
Move the question.
All right, yeah. All right. All right, any further discussion?
Move the question.
All those in favor?
Aye.
Opposed? Abstained. So we have one opposition and 6 in favor. Okay. That's it for that particular agenda item. Under old business, draft minutes, there was an article in the paper this week about draft minutes, and a letter from the I guess it was from the selectmen or something like that.
Yes.
But Jim being the secretary of the planning board, I asked him to comment on this.
I brought it up because I'd read it in the Enterprise and brought it up as a question, but I guess if I had read the policy, there's a definition of applicability, and it really specifies that the policy applies to the posting of public minutes and notices, agendas and minutes for all committees appointed by the Board of Selectmen and its subordinates, which would leave us outside of that scope. And my question probably, if I had read this, I wouldn't have asked the question.
Okay.
But we, Chairman,
Yes?
we did put on the webpage that draft minutes are available upon request.
Okay.
So if someone wants a copy of the draft minutes, call the office, and Joyce will be happy to send you out a copy that says, draft stamped on it.
Okay, that's fine, I don't think anybody objects to that. All right, and then the Transportation Subcommittee, which was an issue that Bob brought up. Bob, you want to speak to that at all?
Well, has there been any effort made to connect to the existing Transportation Committee members? Did we decide what we were going to do with that? Were we going to approach them? Was the planning office going to write a letter to them, or Ralph, were we going to draft a letter to them? I'm not really sure where we left it.
It was in the minutes, and why don't I have my minutes?
The board wanted to discuss whether or not we wanted to resurrect this group or become this group as a subcommittee of this board that's working on a local comprehensive plan, was the question that Bob raised and wanted to be put on for discussion at your next agenda, which is this week's. So those are 2 policy questions. Do you want to resurrect the committee as a separate committee, or does this board want to assume some of the some of the roles of that former committee under the local comprehensive plan. There is a transportation element for planning purposes. And that's the question, I think, as I recall, in my notes that Bob raised. A or B. A, resurrect the committee. B, assume some of those responsibilities. And C is always the no action option.
So are you okay with that?
Yeah, yeah,
Okay. Because the minutes did indicate that we would discuss it
right.
tonight. Okay.
So I'd like to get the board's feelings on, do we go this on our own, or do we try and resurrect the Transportation Committee that fails to have a quorum?
Paul?
My understanding, the Transportation Committee was very well established, worked very hard, and produced a report, which I have not seen for one. And there was some disagreement with the Board of Selectmen, and that all the members resigned en masse. I don't know the details of that, I don't recall that, but it might be helpful to find out what the report was. They must have some document that they submitted that causes friction. I don't know what it was. It may be helpful to have that particular document before we move too far along on trying to resurrect something or do something totally different. So I would suggest we try to get a copy of the draft report that was produced 2 or 3 years ago, whenever it was.
Other comments?
Good idea.
It's a good idea.
Jim?
Well, I think, I like the idea of bringing up if it possible, as a subcommittee to our group. I mean, especially when we're working on the long-term comprehensive plan. We don't have anyone to reach out onto transportation on that issue, because this committee's not there. And maybe they belong as a subcomponent of the planning group instead of the selectmen. Because then we could take their feedback and use it on our planning. So, and instead of just having, I think what they got and tried as selectmen is they were writing policy. I think if it's a little slower if you do it planning, it takes a little time, and then goes to town meeting, and it has more of a process. And I would like to have that input from groups working on that towards that process, and not, that way they won't get shut out when they just do a policy and get slammed and it's no. We lost that dialogue. I'd like to gain it back.
Whatever we might decide on that, Paul's suggestion that we first try to locate the work product of the prior group would be a no-brainer, since why try and reinvent the wheel? Why not at least use that as a starting point? So I think that should be the first task for the planner, is to see if he can locate a copy of that someplace to have us look at it.
That's what I got.
I'm sure you did.
What's the GMC up to?
Right.
Should be available.
Okay.
So if we had that for the next meeting,
So with that discussion about the transportation subcommittee, or no, transportation committee, I mean, if our minutes are referencing a transportation subcommittee, which would have been a subcommittee of the planning board, which was one of the possibilities,
right.
of which I personally would not be in favor of, but I'd be open for discussion. Okay, are we good there then? That Brian's going to see if he can find that.
If such a document exists, get yourselves a copy for next agenda.
Yeah.
Okay.
There's no point of any further discussion until we have that.
Okay.
Right.
All right. Are there any committee reports that somebody would like to make tonight? Any committees that you're representing the planning board? Okay, if there are none, then correspondence, we have in the correspondence folder, we have a copy of a memo. Every person gets one from town council concerning a conflict of interest, which there's specifically reference the planning board, and it also says that can I have the cover letter? The cover letter says, I enclose herewith a training memorandum from the State Ethics Commission specific to planning boards. Please distribute a copy to each member of the board. The Office of Town Council will conduct a training session in September of this year. Of course, any member of the board may contact this office for advice about the conflict of interest law at any time. So, that's just a, I'm sure most of you, if not all of us, have attended training sessions by the town council before concerning the conflict of interest law, but here's some more cannon fodder for your thoughts. Okay, let's see, I'll keep my copy, I'll leave the cover letter back in here. And that wraps up the correspondence, so that's the last item on the agenda, unless somebody has something that they want brought up at a future meeting, under what we call new business, actually. Anybody? No.
Your meeting schedule, for your information.
Oh, yeah.
You'll be meeting next week, the 24th. There'll be no meeting on the 31st of July. Then you'll be meeting again on August 7th and August 14th. After that to be determined. We're trying to schedule a public hearing. We're going to have a lot of regulatory work, I'm afraid. There's going to have to intervene. We're going to have some plan reviews coming in on August the 7th. Teledyne Ventos, more than likely, as a plan review. And my guys have the other information, but a lot of regulatory work on the 7th. We're trying to get to the public hearing on the turbine on August the 14th. And I'll give you then 3 full weeks before the close meeting.
Okay.
So we'll be talking about, next week will be important. It'll be pretty much a meeting devoted to turbine bylaw. Maybe the 31st, it gives us time to catch our breath and put it all together, get your regulatory work done, and then hold that. And that still gives you some time to wiggle room before the warrant closes, about 3 more meetings.
Okay, yeah, Doug, what?
So that would be a good target date to get our draft online for like August 7th or something, so that it could be viewed by the public a week before the public meeting?
Once you publish a hearing, there'll be a draft, a hearing draft, and will be available at the office and on.
But I mean, prior to the public hearing, if it were online then, that would be a good time.
Yeah,
People
well,
could,
I'll have this up online, and then whatever you discuss on the 24th. And again, on August 7th, you're going to have a lot of regulatory work at the end. But at the end of that meeting, I'll ask you probably to clean up any language for your hearing the next week.
I see, so you're going to go ahead and put that on regardless now? I
Right
see.
now, this will be a public document with a caveat that the board will be having further discussions. This is the last discussion draft. Changes will be coming. Additional information will be forthcoming, and changes will be are not reflected on this draft that the board discussed on its meeting on Sunday.
Okay, and I need a motion for adjournment.
I move adjournment.
Second.
All those in favor?
Aye.
Adjourned.